Good afternoon, ladies and gentlemen. I'm Steve Perkins, President of the Colorado Motor Vehicle Dealer Board. Today's date is September 18th, 2018, and the time is 1 p.m. These proceedings are being recorded as part of the standard process of rulemaking by the board. I've determined that a quorum of the board is present, so it is possible to proceed. At this time, I'd like to call for a motion to open the hearing to consider proposed rule revisions and proposed new rules related to both 1 CCR 205-1 regarding motor vehicles and to 1 CCR 205-2 regarding power sports vehicles. The board will consider both proposed revisions to existing rules and also proposed new rules. Specifically, the board will consider proposed revisions to the following rules. Motor Vehicle Rule Number 12.6.104, parens 3, parens A. Motor Vehicle Rule Number 12.6.104, parens 3, parens D, Roman numeral 2. Motor Vehicle Rule Number 12.6.104, parens 3, parens F, Roman numeral 1. Motor Vehicle Rule Number 12.6.104, parens 3, parens O, and Motor Vehicle Rule Number 12.6.104, parens 4. Specifically, the board will also consider the following proposed new rules. Motor Vehicle Rule Number 12.6.104, parens 3, parens F, Roman numeral 2. Power Sports Vehicle Rule Number 12.6.504, parens 1, parens A. Power Sports Vehicle Rule Number 12.6.504, parens 1, parens D, Roman numeral 2. Power Sports Vehicle Number 12.6.504, parens 1, and Power Sports Vehicle Rule Number 12.6.504, parens 1, parens F, Roman numeral 5. Is there a motion to open the rulemaking hearing?
Motion.
Mr. White, first, second by Mr. Woodholm.
After read
Yeah.
Oh,
I, Jason White, as a member of the Motor Vehicle Dealer Board pursuant to the authority of the board, in Colorado Revised Statute, Section 12-6.104, parens 3, parens A, and 12.6.504, parens 1, parens A, to promulgate, amend, and repeal rules pursuant to the provisions and procedures in and arising from Colorado Revised Statute, Section 24.4.103. Move that the board open and conduct a rulemaking hearing on the proposed new and revised rules and proposed deletions of existing rules that were given public notice by publication of the Colorado Register, Volume 41, Number 16, on August 25th, 2018, under tracking numbers 2018-00398 and 2018-00399.
thank you.
I second that motion.
Mr. Woodholm, second. Is there any discussion? Hearing none, all in favor? All opposed, seeing none, motion passes unanimously. The formal rulemaking hearing is now open. The hearing will proceed according to the provisions of the Colorado Administrative Procedures Act, specifically Section 24-4-103 of the Colorado Revised Statutes, and according to other relevant provisions of law, regulation, and policy. Today's rulemaking hearing received official public notice on August 25th, 2018, by means of publication in Volume 41, Number 16 of the Colorado Register. Public notice for rules found in 1 CCR 205-1 related to motor vehicles came under tracking number 2018-00398. Public notice for rules found in 1 CCR 205-2 related to power sports vehicles came under tracking number 2018-00399. Supplemental public notice took place through publications of the websites of the Department of Regulatory Agencies and the Auto Industry Division of the Department of Revenue. It is important to note that today's rulemaking hearing materials are under the statutory framework of Title 12 of the Colorado Revised Statutes because until October 1, 2018, the Title 12 statutory framework remains in place. However, as of October 1st, 2018, the Title 12 statutory framework will be replaced by statutory framework under Title 44 of the Colorado Revised Statute. Because the board's rules are currently framed under Title 12, they will also transition to Title 44 on October 1st, 2018. Therefore, by the time that the rules in today's rulemaking become effective, they will have rule numbers associated with Title 44. Today's rulemaking hearing offers any interested persons the opportunity to make oral comments to the board on one or more of the rules under review or to provide additional documents for the board's consideration or both. The hearing is quasi-legislative in nature, not adversarial. All viewpoints are welcome. Anyone can speak and share information and opinions regarding the rules under review. Anyone who wants to make comments to the board and or provide additional document to the board must mark the appropriate yes box beside their signature on the attendance sheet. Right before I open the public comment phase, I will look over the attendance sheet, add the number of persons who want to make comments, and determine if the number of persons is large enough to require that each person be limited to more than a particular number of minutes that I can declare before the first speaker comes forward. The board can, of course, agree to accept a given speaker's request to enlarge the time for their presentation. All speakers are urged to make their points as succinctly as possible. The board has before it the record for board review. Included in the record are the following: the current text of each of the rules the board will consider in the rule-making hearing, the red line version of the associated clean text version of each motor vehicle related rules for which revisions are proposed, the red line version and associated clean text version of each of the power sports vehicle related rules for which revisions or new rules are proposed, materials related to the stakeholders meeting held on July 26, 2018, filing and notice materials related to the Secretary of State's office tracking numbers 2018-00398 and 2018-00399. Filing and notice materials related to the Department of Regulatory Agencies filings numbers 7557 and 7558. Notice of hearing with proposed draft rules to interested persons. Comments from interested persons and the public received after the publication of the official notice of hearing and through September 14th, 2018. Relevant web published materials by the Auto Industry Division on behalf of the board. Relevant rule review and rulemaking law, executive orders, and Department of Revenue policy. Mr. Beebe, a subject matter expert for the Auto Industry Division, will introduce the record in general and then provide the Auto Industries Division's position on each separate rule taken in turn. The board will then entertain public comments on the rules. The board members may ask the division and any public commenter as many relevant questions as the board may have regarding any particular rule. After the public comments have concluded, Mr. Beebe will be permitted to comment further as needed on any rule or rules. The board will close the public comment phase of the rulemaking hearing after all public comments and potential additional comments from the division have been made on all of the rules the board has before it for consideration today. Once the board closes the comment phase of the rulemaking hearing, it will not entertain any further comments from the division or from the public. The board will then deliberate upon the written record for board review, together with any written materials made part of the comprehensive record subsequent to September 14, 2018, and including any written submissions in course of the board's hearing today. The board's deliberation will also include oral comments of the division and the public made during the hearing today. The board will deliberate on each rule in turn brought before the board in the hearing today. For each rule, the board will make some decision today. For each rule, the board has options, including but not limited to the following. It may adopt the proposed rule as presented by the division, or it may adopt the proposed rule as presented by the division, but with modifications made by the board, or it may continue its deliberations on the rule until a later date that it announces, or it may reject the proposed rule as presented by the division. If the rule presented by the division is an entirely new rule, then the new rule would not come into existence. If the rule presented by the division is a revised rule, then the rule in its current form continues in existence.
And I would just like to note for the board members at this point that there were scripts that were provided to you on these motions, so take a look through them.
The oral comment phase of the hearing will now begin. Leland Beebe, who is the legal assistant and rules administrator for the Auto Industry Division and the Motor Vehicle Dealer Board, will make the division's presentation of the record to the board. Mr. Beebe, you have the floor at this time. Please proceed with your presentation.
Thank you, Mr. President. Thank you all for being here, and the staff of the Auto Industry Division are pleased to present their recommendations with respect to the rules in this 2018 Rule Group Number 1 set of rules. For some board members and others in attendance, this may be the very first rulemaking process in which they will participate. To this, I would just say to you, have no fear. The record before the board always looks daunting. Here is the record. And it's heavy enough, it's hard to lift. Okay? It is a required compilation of all the rulemaking materials that have been part of the process to date. And the statutes and standards also frame the whole process. Much of it will seem redundant as you read through it, because some of it is redundant of necessity, because the record is a history, and all of the elements of that history have to be present. Okay. Our staff report to you is intended to focus on the regulations under review, carrying forward the drafts as last produced out of the stakeholders group. That group met only once because it felt no need for additional deliberation. The group came to a consensus on the drafts that you see before you. That does not mean that a stakeholder could not change his or her mind now and step forward with a new opinion. That certainly can always happen, and no one is stopped from doing that. The auto industry staff, I will say to you though, have not changed their minds, and they agree with the regulations as they came from the stakeholder group meeting. This staff report will follow the segmentation of the rules on review that each board member has in front of them. And I invite you to, right now, board members, take a peek at this. There are 6 segments, okay? And we will be going through these, each segment in turn, okay? All right. This segmentation exists to facilitate the board's deliberation. It will speed it up effectively. It's the same segmentation, obviously, in the deliberative phase, so this is a practice run for you as I read through what we're going to be talking about. Each segment presents the rules in that segment. First, the rules related to the motor vehicle side of the industry, and second, as related to the power sports vehicle side of the industry. You'll see these are color-coded in a certain way because certain types of changes relate to certain types of things. Okay, so you have red line versions, and you have what we would call a clean version. The clean version is as it would look adopted as such. The red line version will often show the strikeouts, changes to the existing rule, and would also show you the new text in that. Now, that said, there were a number of considerations that went in to the drafting process of changes to these regulations and the drafting process of any new rule that you see here. It is important to make it a matter of record for the board's sake what went into the thought processes that the staff had and that carried through into the stakeholders group. Okay. Almost always we have questions about what do people think about. This is to get around those questions if we can. Among the considerations that are always present in these drafting processes, the first would be whether there were relevant changes to the authorizing statutes that the board must respond to. When a statute changes, your powers change, board, as you well know. And there were such changes in the last two sessions of the General Assembly. And those changes have to be reflected in a review of rules that may relate to those changes. And you'll see some that have been reflected. The second set of things are the legal restraints that exist in the language of a regulation. When a regulation is reviewed originally, there may be standards in place. There are always standards in place. But constitutional interpretations, statutory interpretations, the way words are used, all these things can change across time. So when a review is done of a rule in place for sometimes decades, it's important to catch up, if you will, and to make sure it's all correct. So among those considerations is whether the language in an existing rule is outside the scope of existing authorizing statutes. That is, not permitted or no longer permitted under the current authorizing statutes. In other words, powers can be taken away. Whether language is unconstitutional under Colorado or U.S. constitutions. And again, interpretations come in. Whether language is overlapping or duplicative of language elsewhere in statutes or rules. The last thing one wants is to have things that are potentially in conflict due to differences in context. So it's something everyone watches for in this process. Whether language is unnecessary because the authorizing statutes provide sufficient guidance without further regulation. Again, the statute gives power. Do we need to say the same power again without modification in a rule? The answer to that should always be no. But do we do that once in a while, or has it been done once in a while? Yes, it has. So we review with that in mind too. Whether language is inadequate to achieve the aims of the authorizing statutes. Again, maybe they've changed, or maybe the original interpretation of them's changed, but one way or another, that means inadequate to address the relevant policy matters. For example, consumer protection, healthy business competition, etc. Then, whether language is unclear by modern legal drafting standards, including what now exists called the plain English standard that is mandated by the legislature to be written into all rules and statutes from that point forward. And also with regard to what you would consider a strict adherence to the English language conventions of grammar, syntax, spelling, punctuation, etc., most of which are also written into statutory provisions of the law as requirements. This board has also a very unusual mission every time rulemaking begins, and that is to examine what may need to be considered parallel rules between the side of the industry that is the motor vehicle side and the side of the industry that is the power sports side. You may or may not realize that the two enabling statutory schemes that are joined together at the hip are not perfectly identical, although they are almost always identical. So when something is passed in one, you need to ask, should it be also passed in the other? And that was a primary consideration, as you'll see again and again in this set of rules before you. So therefore, we took them up in pairs in the stakeholders group, and they're being taken up in pairs here. Okay? There are occasions when you need to depart from parallelism. I don't believe there's any of that today. Now I'd like to move on to the individual rules in each segment. Beginning with segment 1, if you would turn to segment 1. Okay. Okay, segment one concerns two rules. One, a proposed revision, the other, a proposed new parallel rule. So, for 126104-3A, it's a proposed revision, that being a motor vehicle rule, and the second, there never has been a parallel rule, therefore a proposed 12610504-1A has a parallel. Okay, now, there's always some history that needs to be looked at here, and the power of the statute needs to be found. The statutory language that is the foundation of this rule is in the current title section, 126104, parent 3, parent A, and it authorizes this rule. And the language is this: the board is authorized and empowered to promulgate, amend, and repeal rules reasonably necessary to implement this Part 1, including the administration, enforcement, issuance, and denial of licenses to motor vehicle dealers, motor vehicle salespersons, used motor vehicle dealers, wholesale motor vehicle auction dealers, and wholesalers, and the laws of the state of Colorado. This is a very important distinction we're about to make here. The statutory language explicitly addresses the board's authority to do rulemaking. This is a statute about rulemaking. Quote, the board is authorized and empowered to promulgate, amend, and repeal rules. That's the lead line. However, the existing regulation does not delegate the board's authority to do rulemaking, but mistakenly delegates enforcement authority of rules and regulations. Therefore, as currently worded, this regulation stands outside the scope of the authorizing statute. Perhaps the AG would like to comment here. Do you agree with that?
Yes.
And I know for the board members, what Mr. Heedy is referring to is the current text of the regulation in segment 1, and then you'll see the proposed revisions in the red line on the next page.
Sorry. Thank you. Yeah, there is always the current text in front of you too in that each segment. Now, one remedy for this violation of the scope of the statute would be to delete the rule completely and leave the delegation respective to the actual authority in the statute alone. That is always an option. However, the staff and, I will add, the stakeholders group believes that the better course is to revise the rule to delegate administrative aspects of rulemaking to the executive secretary and his agents. A need exists for such delegation. Rulemaking activities, this one included, are currently administered by aid staff, you got it, according to the provisions of the APA, the governor's orders, and the Department of Revenue policies, but without explicit delegation by the board to perform these administrative duties. The staff and the stakeholders group believe that the revised rules will provide that authority. So that is the purpose of it. So we're correcting an error from the past and enabling a process exactly the one we're involved right now to exist under the board's delegation. Okay, the power sports parallel rule is in the same language. There's no principal basis to do anything different for power sports. Therefore, the staff believes the need exists to have a completely parallel rule for power sports. Moving to segment 2. Two rules again. One, the first, a proposed revision to the motor vehicle rule number 126104, parent 3, parent D, Roman numeral 2, and a proposed new parallel rule for power sports under the header 126504, parent 1, parent D, Roman numeral 2. Now, looking at the motor vehicle rule that would be revised, the authorizing statute, section 126104, parent 3, parent D, Roman numeral 2, for this rule states, the board is authorized and empowered to permit the executive director or the director to issue licenses pursuant to rules adopted by the board pursuant to subsection 3A of this section. The current rule is a delegation of authority from the board. However, the authorizing statute does not give the board permission to delegate this authority, but rather gives it the authority to permit the executive director, etc. to act. Now, this may seem like a what we call nicety at law, but it's an important one. The regulation needs to be amended to recognize the actual authorization the legislature has provided. Therefore, the change in wording does that. The statutes have also changed since the rule was written. Now the director and the executive director are the appropriate figures to receive the authority. That is 2 figures, not the executive secretary and the auto industry division. This is where statutory change can completely affect the process of and the ordering of activities in an agency. And it's important to recognize that through this kind of rule change. Now also, the authority the legislature permits must be expressed not in guidelines, but in board rules. That is a change too. Therefore, all of the above have been addressed in the proposed revisions to this rule. Moving to the power sports rule, again, it's a completely identical rule, parallel because there is no principal basis to have it be different, and therefore the staff believe the need exists to have a completely parallel rule for power sports. I'm pushing through this. I know faster than probably people can read, but deliberations are coming. Segment 3. Okay, segment 3 again involves a proposed revision of a motor vehicle rule number 126.104, parent 4, and a proposed new parallel rule under 126.504, parent 1. Probably of this entire set that you're going to look at today, this one involves the most advanced legal thinking for you and obviously for the stakeholders group and the staff. And here's why. The current motor vehicle version has a significant history. The highlights of this history are important to make of record. Number 1, in the years between 2004 and 2006, many concerns surfaced and complaints were made about the board's alleged inconsistency and unfairness in its determinations of sanctions against licensees. Number 2, an existing statutory provision, 12.6.104, parent 3, parent N, has been ignored by the board for many years. That provision stated, quote, "The board is authorized and empowered to promulgate guidelines in the form of rules and regulations to ensure that administrative penalties are equitably assessed and commensurate with the seriousness of the violation." The statutory language did not mandate that the board take the desired action. That's important. They were authorized and empowered, but it didn't say you shall do it. It merely authorized and empowered the board to do so. The board did not create the regulations that would ensure its sanctions were equitable and commensurate with the seriousness of the violation. It's a matter of history. Therefore, in the 2006 Sunset Review, the reviewer received many complaints by this time about board sanctions. As a result, recommendation number 10 of the 2006 Sunset Review stated, quote, "The AID, the Auto Industry Division, and the board should develop and utilize a viable and consistent set of compliance and disciplinary standards by January 1st, 2008. That was a recommendation from that DORA reviewer. The sunset legislation that followed deleted the former merely empowering and aspirational provisions of 12.6.104.3N and replaced them with a severely time-constrained mandate in section 12.6.104, parent 4, where it says, "The board shall promulgate rules by January 1st, 2008, establishing enforcement and compliance standards to ensure that administrative penalties are equitably assessed and commensurate with the seriousness of the violation." Obviously, the legislature was impressed by the number of complaints that came from the outside stakeholders. The board quickly promulgated the current formulation of 1 CCR 205-1, Regulation 126104 in response to this mandate. The regulation, as you see, has remained unreviewed and unchanged for the last 11 years. Now, an examination of that rule made 11 years ago using modern drafting process considerations revealed a number of issues. Among them are concerns about some of the provisions of the rule exceeding the scope of the authorizing statute as that statute now exists. I'd like to turn, if I could, to the AG, Mr. Jones, to say anything he might want to say about that.
Thank you, Mr. Beebe. So what Mr. Beebe is referring to is that if there is a rule in existence and it's revised or readdressed in any manner, it has to have correct statutory authority. Otherwise, what can happen is that the Office of Legislative Legal Services will review the rule and will take it to the legislative committee that will address whether the rule should be eliminated because it's going beyond the statutory authority granted to the body that it is promulgating the rule. And why that matters for the sake of 104.4, if you read through the current text, is there's a lot of references that go beyond the statutory reference, which is in 12.6 104.4. And that talks about, again, promulgating rules, establishing enforcement and compliance standards to ensure that administrative penalties are equitably assessed and commensurate with the seriousness of the violation. So those are looking at the penalties and what can be assessed against a licensee for whatever violations the board deems a licensee committed. And because of that, in the current context, this rule appears on the face of it to go beyond that provision. And so in reassessing it, you're looking at the statutory authority to determine what statutory which provisions in this regulation go beyond the statutory authority. Now, the reason that this matters is, as I mentioned, the committee can designate a bill as going beyond statutory authority, and what that means is that they can place it in a legislative bill during a legislative session, and all of the regulations listed in that bill will be deleted for going beyond statutory authority, unless the industry or the agency itself can pass a bill, a legislative bill during that session to give themselves authority. This alleviates that issue, is by tailoring the regulation and splitting it, in fact, into two regulations that Mr. Beebe will touch on. It is alleviating that issue and rewriting regulation 12.6 104.4 so it is limited to the authority that is granted in the statutory text.
Thank you. So, exactly what Mr. Jones said, in the staff original review and then through the stakeholder group meeting, it was deemed appropriate to curtail the overreaching language, reformulate the rule, and essentially piece it into two to place some of the materials in that current rule that don't belong there into another rule location where they do belong. So that means that it will be appearing in segment 4, which I'll talk about presently. Now, the need to create a parallel in power sports is here. There is none. So what has happened is the revised rule in 12.6 104 has become virtually the new rule in 12.6 parent 1 because there's no principal basis, we believe, to make a difference there. And that concludes segment 3's presentation. Segment 4. Segment 4. This is a proposed new rule for both motor vehicles and a new parallel rule for power sports. Now, the content of this new rule is in some ways reflective of content that existed before or was in fact contemplated before. So this is not a stranger to us all. Okay. So that we're looking in this segment for the second of the two pieces. And the staff believes it's important to memorialize by rule the process that the board uses in disciplinary cases brought to it by the division. The proposed new motor vehicle and power sports regulations address that process. It should seem familiar to every board member here, since that process has been in use before, essentially. It may contain a few more features, but those are not strange or alien features. And so the staff and with the concurrence of the group that reviewed this earlier and talked about it, we feel that both of these are necessary to place as rules in your rule set. That was a very brief discussion of segment 4. That's all there is.
I will add one thing onto that, is just based on my previous discussion regarding segment 3, much of the language in their existing 12.6.1044 regulation was the basis of formulating this new regulation, but it's placing it under a new regulation just for purposes of the statutory authority issue that I mentioned. Thank you.
Now, segment 5 is a bit different. We don't often do this, but when it's necessary, as we believe here it is, we will recommend it. So, motor vehicle rule number 12.6.104, parent 3, parent O, does not have a parallel rule in power sports. But the staff is proposing a deletion of this rule. So essentially, it's just going to be removed if you pass this. Based upon the drafting considerations I went over in the introduction, and significantly based on legislation that was promoted by CIADA that passed in the 2017 legislative session through House Bill 17-1249, House Bill 17-1249, and has been amended in the 2018 legislative session through House Bill 18-1105. The staff and with the concurrence of the stakeholders group no longer saw any reason to retain this rule. Therefore, the staff recommends this rule be deleted. This is an example of something that ceases to have a need for an independent rule when statutes have changed that adequately address the problem. And again, there is no parallel rule, and the staff would recommend that one not be created, since we believe that the rule that would be made parallel to should be deleted. Okay. So that's it for segment 6. Pardon, 5. Moving to segment 6, which is the last segment. Okay, this also involves a deletion. This time of Rule 12.6.104, parent 3, parent F, Roman numeral 1. Okay. Statutory changes again in 2017 as a result of the sunset legislation removed the need for this rule. The roles of the executive secretary, the director, the executive director, and the board with regard to initiation of investigations are spelled out more carefully than was the case in statutory language that was there before. This is an example of where you shouldn't need to have a rule if the statutes are adequate to address the issue. And it was the concurred opinion that the language in the statute is adequate and the rule is no longer needed. Therefore, the staff is recommending this rule be deleted in its entirety and that no parallel rule obviously be created for power sports. Now that concludes all 6 of the segments of these rules. My concluding comment would be that the staff is recommending that the proposed changes, as you see them in the proposals, be enacted as proposed and in the language as proposed. Now that may sound odd, but as proposed would be for recommending a change, that you change it. If we're recommending a deletion, that you delete it. If we're recommending a new rule, that you make a new rule. And in the language as proposed, of course, that speaks for itself. Thank you for your consideration.
Thank you, Mr. Beatty. The division has finished its presentation of the record, and it's time to hear comments from the public. If anyone in the audience has not signed the attendance sheet, please do so now. If anyone has signed the attendance sheet but didn't mark the box beside their name indicating they would like to address the board, please do so now. Your case. Based on the number of persons who have indicated they want to address the board, it is not necessary to limit the time for each person to speak. I've determined that it is not necessary to limit the time for each person to speak. Please, everyone, make your comments as succinct as possible. If anyone has additional documents they want to provide to the board, please hold up your hand. A representative of the division will take those documents from you in order to make enough copies to provide each of the board members present, the Attorney General, to the subject matter expert, and for the official record. Once the documents have been copied, the original will be returned to you for you, or if you prefer, refer to it in your presentation, and the copies will be provided to the board at a brief break in these procedures for that purpose. Just to be certain, has everyone who wants to provide documents to the board given them to the division will be copied? This is an easy group to do.
I would note for the record that, I would just note for the record that there's no one indicating that they have additional documents to present to the board.
Now at this time, would Mr. Todd O'Connell if you would identify yourself and spell out your name for us, please?
I'm Todd O'Connell, Toddoconnell. I am the CEO of the Colorado Independent Automobile Dealers Association. And first of all, I'd like to accept your gracious offer of unlimited time. However, this will only take a second. First of all, I want to commend the Auto Industry Division's leadership and the staff in the way that this Group 1 rulemaking was structured. In the past, we basically started with a blank sheet. With this rulemaking session, they had guidelines down which precipitated very quality discussions on each particular rule, which provided for a very efficient process. I attended the stakeholder meeting along with CIADA's attorney Mike McKinnon, and we are in complete consensus with Mr. Beebe's statement in Auto Industry Division that we feel that the rules should be adopted as proposed, and I'm not sure I have all the legal jargon, but with that, appreciate the time. Any questions?
Mr. O'Connell, thank you.
You betcha.
Question from the board? No. Is there anyone else from the public who wants to address the board? Let the record reflect that there are none. Mr. Beebe, does the division have any further comments it wants to make with regard to the rules being considered today?
I do not personally have any. Mr. Zuloff, if you have any that you would like to chime in with as far as your role as Executive Secretary of the Board and Auto Industry Division Director, I will yield the floor to you.
I would just chime in as both Division Director and Executive Secretary to the Board. I have statutory authority to make a recommendation as your Executive Secretary to the Board, so rarely when I'm given that opportunity do I not take it. So there was, like Mr. O'Connell said, and the staff, we spent a lot of time reviewing this Group 1. This was the first time that I can remember that at the end of the stakeholder meeting, we had consensus when everybody walked out the door that, yeah, this was the right thing to do for this group. So I appreciated the stakeholders who came in from the outside with that. I'll just make myself really brief. Pursuant to my statutory authority to make a recommendation to you, I'd make a recommendation that you adopt the rules as they have been presented by Mr. Beebe this morning, or this afternoon.
Thank you.
And then one last, Mr. Jones, do you have any comments you would like to add at this point?
I don't have any additional comments other than that. Trying to think, none at this time. Thank you, Mr. President.
Mr. Jones, thank you. We've reached the conclusion of the oral comment phase of the rulemaking hearing. I would like to thank everyone who has participated in the process today and everyone who has otherwise participated in the rulemaking process to date for all of their input and hard work. At this time, I'd like to call for a motion to close the oral comment phase of the hearing to consider proposed rule revisions and proposed new rules related to both 1 CCR 205-1 regarding motor vehicles and to 1 CCR 205-2 regarding power sports vehicles. Is there a motion to close the oral comment phase of the rulemaking hearing?
I, Mike Whithelm, board member, hereby move that the board close the comment phase of the rulemaking hearing on the proposed new and revised rules and proposed deletions of current rules that were given public notice by the publication in the Colorado Register, Volume 41, Number 16, on August 25th, 2018, under tracking number 2018-00398 and 2018-00399.
Thank you. Is there a second?
Second.
Mr. White, second. Is there any discussion? Seeing none, all in favor? All opposed? Seeing none, motion passes. The motion to close the oral comment phase of the rulemaking hearing passes. The oral comment phase of the rulemaking hearing is now closed. No further comments from the public or the division will be allowed. It says I'm supposed to offer taking a break. Does anybody need to take a break? No? Thank you. The board will now begin the deliberation phase of the rulemaking hearing. The deliberation phase is open to the public, but only board members and the Attorney General representative are permitted to participate. It is important that everyone remain silent during the board's deliberations. If you have not already done so, please turn off your cell phones. The deliberation phase will take place in distinct segments. Each segment will involve the board's discussion and determination of the rule or rules making up the particular segment. At the conclusion of a segment, the board will vote on the rule or rules comprising that segment. If more than one rule is in a segment, a separate motion and vote will occur for each rule. Today's hearing includes both motor vehicle-related rules and power sports vehicle-related rules. Many of these are parallel rules to one another. Therefore, following the board's tradition to ensure efficient discussion and consistent formulation of language whenever possible, some segments in today's deliberations will incorporate deliberations on both a motor vehicle-related rule and its parallel power sports vehicle-related rule. If a rule is unique to motor vehicles or to power sports vehicles, it will be the only rule in a given segment. The board members will have in front of them a packet of each segment. Included in each packet will be a current vision of each rule in the packet, the red line version showing the changes proposed for each rule in the packet, and the clean version showing how the rule would look if the proposed changes were all adopted. The materials in each packet are extracts of relevant pages in the record for board review under headings A, B, and C. The page numbers shown in the packets match the page numbers in the record for the board review. Therefore, the deliberations will progress segment by segment as follows. Segment 1, A, Motor Vehicle Rule 126104, paren 3, paren A, a proposed revision to the rule, and B, Power Sports Vehicle Rule 12-6-504, paren 1, paren A, a proposed new parallel rule.
And we can stop.
Take the break. Okay.
So I'd like to just remind the board, before you have the scripts for whatever motions you deem necessary. And I ask that you refer to them when making a motion. And you have to make a motion for each specific rule. It cannot be by segment. So for instance, for the first one, it has to be a motion affiliated with the proposed revisions to motor vehicle rule regulation number 12-6-104 3A.
Any discussion?
I just may have a question on this one. I just wasn't good. The language being removed discusses enforcement of rules and regulations, and the new language obviously is related to rulemaking. I just wasn't sure what's actually happening there, I guess, since the language being removed seems not to relate to the new proposed.
Sure. So I can answer that because this is something I touched on earlier. It goes back to statutory authority. And specifically, this is something Mr. Beebe mentioned in his discussion and something that was discussed during the course of the stakeholder meeting, is under 12-6-104 3A, it discusses to promulgate, amend, and repeal rules reasonably necessary to implement this part 1. And it's saying that the board is authorized and empowered to promulgate and amend and repeal rules. So this regulation is just being tied more specifically to the authority granted under the statute, and that is to engage in rulemaking. And specifically, it's providing guidance that the executive secretary and his or her staff or agents are authorized by the board to assist in that process.
Yeah, so the enforcement of rules is still contained elsewhere in rules and statutes.
Correct.
Good question, Mr. Lemon. Any further discussion? And we want to take motions on a segment basis?
It has to be by rule.
Right, but by rule, but by segment, as opposed to the end and going back.
Correct.
Okay.
Yeah.
So each A and B has to be independent,
Yes.
Yes,
so we can make a motion.
yes, you may.
I, Jason White, move that the Motor Vehicle Dealer Board adopt the proposed rule as given public notice by publication in the Colorado Register, Volume 41, Number 16, on August 25th, 2018. Do I need to read the Motor Vehicle Rule 12-6-104 3 and A?
I second that motion.
First by Mr. White, a second by Mr. Wilhelm. Further discussion? Mr. Jones? Okay. Hearing none, all in favor? All opposed? Seeing none, motion passes unanimously.
I, Jason White, move that Motor Vehicle Dealer Board adopt the proposed rule as given public notice by publication in the Colorado Register, Volume 41, Number 16, on August 25th, 2018. The Power Sports Rule 12-6-504 1A.
I'll second that one as well.
First by Mr. White, second by Mr. Wilhelm. Further discussion? Hearing none, all in favor? All opposed? Seeing none, motion passes unanimously. Segment 2, A, Motor Vehicle Rule Number 12-6-104, parens 3, parens D, Roman numeral 2, a proposed revision to the rule, and B, Power Sports Vehicle Rule Number 12-6-504, paren 1, paren D, Roman numeral 2, a proposed new parallel rule. Any discussion? Group is very tight-lipped today.
I think the key word there is just that the board authorizes the director, correct? Authorize being the key word in that.
Yes. So what the statute specifically says is that the board is authorized and empowered to permit the executive director or board director to issue licenses pursuant to rules adopted by the board. It goes on to talk about the section, and that is under 12.6.104, 3, D, Roman numeral 2.
Good clarification, Mr. Wilhelm.
No additional comments. I, Michael Whithelm, move that the Motor Vehicle Dealer Board adopt the proposed rule as given public notice by publication in the Colorado Register, Volume 41, Number 16, on August 25th, 2018. Motor Vehicle Rule Number 12-6-104, parens 3, parens D, Roman numeral 2.
I second that.
First by Mr. Wilhelm, second by Mr. White. Any discussion? All in favor? All opposed? Seeing none, motion passes unanimously.
I'll make a motion for the second rule too. I, Michael Whithelm, move that the Motor Vehicle Dealer Board adopt the proposed rule as given public notice by publication in the Colorado Register, Volume 41, Number 16, on August 25th, 2018. Power Sports Vehicle Rule Number 12-6-504, parens 1, parens D, Roman numeral 2.
We have a motion by Mr. Wilhelm,
Second.
second by Mr. Linton. Further discussion? Hearing none, all in favor? All opposed? Seeing none, motion passes unanimously. Segment 3, A, Motor Vehicle Rule Number 12-6-104, paren 4, a proposed revision to the rule, and B, Power Sports Vehicle Rule Number 12-6-504, paren 1, a proposed new parallel rule.
Just a clarification point. When it talks about the mandatory sanction, is that when we would go to our grid that will be determined later?
So I can answer that. What that's specifically referring to is there's certain statutory provisions where there is a required result. The most common one, and I think the only one the board really deals with is under 12.6.118, 7A, and that's the mandatory disqualification for crime encompassed under Article 3, 4, or 5 of Title 18 when there's a felony conviction. And so that is a specifically mandated requirement by the General Assembly. For the rest of these, that's when you would be turning to the matrix that the board has discussed and Mr. Zuloff has discussed during the course of board meetings. And that is something where it's more of a guidance principle. This is the basis that is laid out in the rule that will be the framework for determining the level of matrix. But these are the conditions that the board would take into consideration when determining the appropriate level of discipline, whether it's for purposes of looking at a stipulated final agency order through a stipulation, or whether it's imposing determination following a hearing, or when reviewing a initial decision by a hearing officer or administrative law judge.
So we had the mandatory earlier today, felony disqualifying conviction.
Right.
And the guidance matrix is just that. We get to consider all the relevant facts in determining what that fine can be and look like. Good question, thank you.
Did that sufficiently answer your question?
It did. That clarified it.
Further discussion? Guess I'll make a motion.
I do have a question under C1. The fine must be punitive and not compensatory. Mr. Jones, will you illuminate for us?
Yes, so this was a carryover from the original regulation, 12610444. Since I can tell you there was a discussion during the stakeholders meeting regarding whether that should be kept or not. What it means punitive is that the board is not seeking any compensatory damages on behalf of a third party. It's just saying that a licensee engaged in some type of violation, and therefore they have to pay the associated fine that the board deems appropriate under the circumstances. The board is not taking money and ordering them to pay money in order to compensate somebody. Now, there may be situations like we saw in a board meeting recently, as in this morning, where the parties can stipulate to them reimbursing a consumer or a third party. But these fines that you are imposing are specifically tailored to being punitive for violation of the statutes that authorize the board to act. And there was consensus at the stakeholders meeting regarding that terminology.
And we're not taking that money and giving it to a victim.
No, it would go into the general fund for the state of Colorado. Sorry, I blanked out on the title. So it's a general fund that is not even going to a cash fund. Cash fund, I apologize. Goes into a cash fund, and that is not something that the auto industry division or the board can draw from. It goes to the state as a whole.
So this still empowers the board if we're seeking to have a victim not necessarily be made whole, but to use our fining authority to incentivize the dealer to do the right thing. Is that a fair way to?
Yes and no. I think what this does is it lays the framework, the general framework for the process that the board will adhere to. And what you're talking about is more tailored to the matrix that the board previously created and approved, and it seems like the board will be addressing. So this is the general framework, and when the board readdresses that matrix for determining appropriate levels of fines and discipline, that is something that you could bring that in as a factor. This is merely just establishing that any fines that are imposed are going to be punitive, not compensatory. The board is not going to be collecting money and then paying it out to individuals. That's not part of it. You take the money in, it goes into the cash fund.
Mr. President, if I may add something?
Yes.
Okay, when you look at the language of this new proposed regulation, or new revised regulation, paragraph B8, 7 and 8, okay, let's look at those as a companion set. So the board is evaluating factors to determine the level of a fine, let's say, or other factors that they may want to impose. And it's saying if there's any additional, aggravating information, obviously something that is more serious that needs to be considered. But the other factor, which was brought in by a representative of CADA as an addition to this original formulated rule, was any additional mitigating information, including but not limited to the licensee's voluntary monetary remuneration to a victim. So it is part of this rule that be a factor that is being considered in the assessment of a fine. Okay?
Thank you, Mr. Beebe. Further discussion? Hearing none. Motion?
I, Michael Whithelm, move that the Motor Vehicle Dealer Board adopt the proposed rule as given public notice by publication in the Colorado Register, Volume 41, Number 16, on August 25th, 2018. Motor Vehicle Rule Number 12-6-104, Parents Ford.
We have a first by Mr. Wilhelm, second by Mr. White. Further discussion? Hearing none, all in favor? All opposed? Seeing none, motion passes unanimously.
I, Michael Whithelm, also move that the Motor Vehicle Dealer Board adopt the proposed rule as given by notice by publication in the Colorado Register, Volume 41, Number 16, on August 25th, 2018. Power Sports Vehicle Rule Number 12-6-504, Parents 1.
First by Mr. Wilhelm,
Second.
second by Mr. Flower. Further discussion? Hearing none, all in favor? Opposed? Seeing none, motion passes unanimously. On to segment 4. Motor Vehicle Rule Number 12-6-104, parens 3, paren F, Roman numeral 2, a proposed new rule. And B, Power Sports Vehicle Rule Number 12-6-504, paren 1, paren F, Roman numeral 5, a proposed new parallel rule.
I think this is the one that just outlines the framework of what we do, correct?
Correct.
So the
So,
violation comes in, yeah.
yes, and this is what I touched on earlier. This broke up the previous version of Regulation 12-6-1044 into two separate regulations. So one addressing the appropriate penalties as determined by the board in disciplinary matters, and then this one is for purposes of handling investigations that are completed by the division and presented to the board as affidavits of probable cause.
So in section D, where it says we may refer the matter to another agency, what would be an example of that?
I do not personally know of any. I could turn it over to Mr. Azuloff to see what he recalls in his memory. A situation that I envision is if there is something that comes up where, for instance, there's, potentially discrimination of some sort that is brought to the attention of an investigator during the course of their investigation. The investigator may refer the matter over to the Colorado Civil Rights Division. Again, I don't have any personal knowledge of whether that's occurred. That's just based on my experience level, potential situation.
Something that would
my
cover it.
understanding is they're very, very few and far between if they even have occurred, whether that situation has arisen.
Mr. Zula? I'm not allowed to testify. Oh,
In your position as an executive secretary, I agree. One other example is if there's a federal issue, if if during the course of the investigation, the division, I believe, finds out anything that is going across state lines that may not be brought appropriately to the board, but may be appropriately addressed through another law enforcement agency or another agency of some sort like that.
The federal odometer issue, right? We turned over to a federal agency. What about a law enforcement agency? Although if it doesn't meet our test, oftentimes we don't turn it over to it. We think there's something criminal, turned over to local authorities?
Yes, that's my understanding. Generally, my understanding is that occurs usually at the investigation stage. So,
Good questions, Mr. Flower. Further discussion? Hearing none? Motion? Mr. White?
Jason White moved the motor vehicle to report adopt the proposed rule as given public notice by publication in the Colorado Register, volume 41, number 16, on August 25th, 2018, motor vehicle rule 12-6, 1043F, Roman numeral 2.
A motion by Mr. White, second by Mr. Woodhull. Further discussion? Hearing none, all in favor? All opposed? Seeing none, motion passes unanimously. Segment number 5.
No.
Excuse me, I apologize.
I was gonna do that.
Thank you.
I, Jason White, moved that the motor vehicle dealer board adopt the proposed rule as given public notice by publication in the Colorado Register, volume 41, number 16, on August 25th, 2018, for power sports vehicle rule 12-6, 5041 FV, or Roman numeral 5.
thank you.
A motion by Mr. White,
Second.
second by Mr. Wilhelm. Further discussion? Hearing none, all in favor? All opposed? Seeing none, motion passes unanimously. Segment 5. A, motor vehicle rule number 12-6-104, paren 3, paren O, a proposed deletion of the rule.
And before we start the discussion, I just want to remind the board of a few things. The board has authority to, under 12-6-104-3A, to promulgate, amend, and repeal rules. Repeal is the same thing as delete. Delete is the more common term that is used, however, so that is appropriate to use. Additionally, there is a script specific to the deletion or the repeal of the current rule, and that is motion script F.
Any
Any discussion?
Because the statute, a new statute exists that addresses this, so this is basically.
Next two votes.
So with segment 5, this rule, that is correct. For this rule, there was discussion during the stakeholders meeting that it was unnecessary and it was not needed anymore because it has not been used. That is one of the goals of agencies, are to eliminate any unnecessary regulations. So the proposed solution was to repeal this rule or delete it.
And it's kind of covered under segment 3 that we just went through, isn't it?
Right.
I, Michael Whithelm, move that the Motor Vehicle Dealer Board accept the recommendation to delete the current rule as given public notice by publication in the Colorado Register, volume 41, number 16, on August 25th, 2018, Motor Vehicle Rule number 12-6-104, parens 3O.
The first by Mr. Wilhelm, second by Mr. White. Further discussion?
That isn't O, not 0, right? Oh.
Hearing none, all in favor? All opposed? Seeing none, motion passes unanimously.
Do we need a motion that moves parallel?
No. Segment number 6A, motor vehicle rule number 12-6-104, paren 3, paren F, Roman numeral 1, a proposed deletion of the rule.
Any discussion?
Is there a motion?
I, Michael Whitnall, move that the Motor Vehicle Dealer Board accept the recommendation to delete the current rule as given public notice by publication in Colorado Register, Volume 41, Number 16, on August 25th, 2018. Motor Vehicle Rule Number 12-6-104, Parents 3, Parents F, Roman numeral 1.
We have a first by Mr. Woodhelm, second by Mr. White. Further discussion? Hearing none, all in favor? All opposed? Seeing none, motion passes unanimously. Wow, we've reached the conclusion of the entire rulemaking hearing. I'd like to thank the board members and everyone else who has participated in the process today. Thank you. Is there a motion to close the rulemaking hearing?
I, Michael Whitnall, as a board member of the Motor Vehicle Dealer Board, pursuant to the authority of the board and the Colorado Revised Statutes, Sections 12-6104, Parents 3, Parents A, and 12-6504, 1, Parents A, to promulgate, amend, and repeal rules pursuant to the provisions and procedures in and arising from Colorado Revised Statutes, Section 24-4103, move that the board close the rulemaking hearing on the proposed new and revised rules that were given public notice by publication in the Colorado Register, Volume 41, Number 16, on August 25th, 2018, under tracking numbers 2018-00398 and 2018-00399.
Is there a second? Mr. White, second. Any discussion? Hearing none, all in favor? All opposed? Seeing none, motion passes unanimously. I declare this rulemaking hearing closed. Thank you, everybody. Good job.